Okay.
Your pledge is.
When we do the meeting.
Yep.
Well, thanks everybody for coming. We're gonna turn it over to Matt Jessup here, and you can take it away.
Okay, thank you. Hello, everybody. My name is Matt Jessup. I'm the Idaho County Civil Attorney, Deputy Prosecutor. I've been asked to give a presentation today on open meeting law. We can go to the next slide. So, full disclosure, I haven't used PowerPoint since college. Quite a while ago. So I apologize. This doesn't come up quite right. I'm not the attorney for the school board. I'm the attorney representing the county, representing the city of Greenfield, but not the school board. So you have your own attorney. You can ask legal questions too. Offering this presentation as general guidance from the prosecutor's office. You should rely on the advice of your own attorney with regards to specific questions about school board open meeting things. Go to the next slide. Idaho has specific statutes on open meeting requirements. That's a hyperlink to it, but it's just to illustrate that it's all available online on the Idaho State Legislature's website. It's Title 74, Chapter 2, discusses the open meeting requirements in Idaho. On the next one, Office of the Attorney General, Raul Labrador, had published a new summarized guidance on open meeting laws in 2023. That's also available for free on the internet. It summarizes all the open meeting law statutes and is a real convenient tool for a quick reference guide if you have any questions about open meeting laws.
Matt, he's got a 2025 version.
Oh, okay, well, perfect. I don't think it's changed much, but if it has, it'll be updated in there and on that other website. Legislative intent. The intent is that we don't do public business in the dark, that we do it in an open meeting where people can view what's going on with your public funds and your public interest in boards that are formed under the statutes of the state of Idaho. The people of the state of Idaho, in creating the instruments of government that serve them, do not yield their sovereignty to the agencies so created. Therefore, the legislature finds and declares that it's the policy of this state that the formation of public policy is public business and shall not be conducted in secret. That is essentially the introduction paragraph to this open meeting law statute and code. Open meeting laws apply to governmental governing bodies. A governing body is two or more members with authority to make decisions. And so it could be as small as a 2-member board. Here for the school district, we have 5 trustees. So you obviously do come under the umbrella of the open meeting laws in the state of Idaho because you have more than 2. Additionally, any committees, subcommittees, or study groups created by the school district would also fall under the open meeting laws. It would need to be stuff that we'll talk about today, things like agendas, keeping minutes of the meetings. I guess theoretically you could have a very informal committee that wouldn't need to follow open meeting laws, but my advice to you is if you ever have a committee, subcommittee, or study group, that you check with your attorney to see if that should follow the open meeting laws and the agenda requirements and the meeting minute requirements. All school district advisory boards, committees, and the commissions, well, this is repetitive. Full disclosure, I stole a Idaho Association of Counties PowerPoint presentation and tried to change it to fit the school district. And so a lot of this is going to be, applies to both, because they're both governing bodies, but some of this will be a little redundant, and we'll just skip past this slide for this redundant on the last one. Generally, meeting roles and responsibilities. The chairman of the board presides over the meeting. A quorum of board members is required to conduct business. For the purposes of school board business, it's going to be 3 or more, right, for a quorum. The clerk of the board or the clerk's designee prepares and publishes the agenda, takes minutes, disseminates information and records of the meeting if required, and the school district staff may be required to attend and provide updates, reports, and answer questions. A public meeting occurs anytime a governing board convenes to make a decision or deliberate towards a decision. That's going to be in a regular meeting, a special meeting, an emergency meeting, or an executive session. the governing body should not convene outside of the sight of the public for any other type of meeting. It's gotta be a regular meeting, a special meeting, emergency meeting, or an executive session. On the next slide. This one is more for counties. I don't think it's gonna apply to the school board. It does apply to you, but you're not gonna have the situation. You can't hold your meetings in any buildings where anybody's excluded based on these protected classes. Race, creed, color, sex, age, national origin. So you can have a school board meeting in, I don't know, golf course that excludes women. It has to be open to everybody that are in these classes. But you can't exclude them because of race, creed, color, sex, age, or national origin. But you guys have your meetings here in the schools, and so you shouldn't have a problem with that section of the law. Meetings may be held telephonically or virtually, as long as someone in the school district is on site and there's a system allowing all governing and board members to participate. So this, I read over this statute, and it doesn't quite say that. This is what the Idaho Association of Counties says. I think you wanna have at least one board member present in the room where you're gonna physically have the meeting. The remaining board members can participate via phone or computer, and you should have somebody that, well, at least one board member should be here. As far as staff, I guess they could be remote as well, but you should have someone on site to make sure that everyone can participate on phone, on video, or in person. Any questions about that one? That one was kind of interesting to me.
During COVID, the guidance was the board and the clerk should be
Board-
present.
Oh,
where-
the entire board and the clerk.
Not the entire board, the board chair.
The
and
board chair and the
should
clerk.
be.
Okay,
That was during the thick of
yeah.
the COVID.
And that's allowed under Idaho statute. The meeting agenda, obviously the meeting agenda is super important to give the public information about what's gonna happen at the meeting. The meeting agenda is important. It should be so basic that anybody who doesn't know anything about school boards or anybody who doesn't know anything about what the school board is doing should be able to understand from the agenda what's gonna happen. So it needs to be simple and descriptive. And there's some requirements for posting. We'll go on some different slides here when it needs to be posted. No, that's perfect. The school board needs to make a good faith effort to include all probable items that are gonna be discussed and decided at the meeting. It's written for those not familiar with school board governance, people who don't know how school boards run or what they do. They need to be able to read that agenda and understand what's gonna happen. It doesn't have acronyms on there. You need to spell stuff out. I'm trying to think of an acronym that we have. What's the federal funding for the forest income? SRS, so probably spell out SRS or those types of acronyms. It says your promise to the public. It is your promise to the public, because this is what we're gonna talk about. This is all we're gonna talk about. There's no sneak attacks where we're saying we're gonna talk about this thing, we're gonna talk about something else instead. It's your promise to the public, this is all we're gonna talk about. The agenda is not a list of categories like old business, new business, adjourn. I guess theoretically you could have those categories in there, but it needs to be fleshed out. It's exactly what you're gonna talk about. So if it's old business, what is that old business? Specifically, what is it? A list of presenters wouldn't be helpful. I'm sure I saw the agenda today, but it didn't just say Matt Jessup presenting. I'm sure it says Matt Jessup presenting on open meeting law requirements, right? And so again, somebody who's just looking at it can understand what's gonna happen. If it just says the name of the presenter, you won't know what's gonna be on the agenda. Requests for actions hidden in reports. For example, I guess you'd have a report maybe from the facilities manager, and inside that report, it's not agendized, but he wants a request to put a new roof on a high school, right? So you can't just say agenda item, maintenance manager report, and then within that, without putting it in the agenda, approving the new roof. You have to put on the agenda, approving the new roof. Types of public meetings. Regular meeting, the regular convening of the governing board of a public agency is a date fixed by law or rule to conduct the business of the agency. I imagine the school board gets to set their own date when the meeting's gonna happen, but the frequency is set by statute. I'm not familiar with school district law on that, but
Required once a month, you have to have your board
once a
meeting.
month. And you guys select the time, date, and location.
at our annual
And
meeting.
postings, that'll happen later today.
Okay, and that's your regular meeting. When you post agendas for the regular meeting, it's gotta be done 48 hours in advance. And you have to post it physically, you gotta post it on your website, and you have to send notice to the local paper, my understanding. I think I have a slide on that. Here's a regular meeting checklist. Before the meeting, here, regular meeting date adopted by ordinance, that's applicable to the counties. I'm sure the school board has an equivalent. The agenda posted 48 hours in advance of the meeting. Physical posting and online posting. So if you have an online presence, which you do, you have to put the agenda on your online website.
So they've removed the newspaper requirement since.
Oh, they did? Okay. And then, oh really?
That's my understanding. And you
I
could
see.
correct me, cause you have that.
No, that's
way
fine. I
more
was just
than
reading
me.
it yesterday. Maybe I was reading that old 2023 manual.
Well, Lori gets it because I sent her.
Right,
She's
well,
on
we
the
send
list.
we send a list of them anyway, but my understanding is now that we are posting online, we no longer
Not
have to do
required,
the paper.
yeah, yeah.
Because some communities aren't as blessed as Grange Valley,
Oh,
don't
sure.
have a
Yeah,
local
the
paper,
Yeah.
and so they run into that.
Sure. And then, agenda amendments need to be made prior to the meeting. If there are agenda amendments identified before the meeting, 48 hours before the meeting. During the meeting, there has to be a quorum present, necessary staff present, agenda amendments made according to Idaho open meeting law, and I have a statute, or a slide on agenda amendments. After the meeting, draft minutes available to the public, draft minutes reviewed by the Board of Trustees. I assume you do that at your next meeting. Minutes approved by the Board of Trustees, and approved minutes made available to the public after they've been approved. Next type of meeting is a special meeting. Special meeting is convening of the governing board, public agency, to a special call. And I know we had some special meetings last year when we were talking about the levy and budget items. Those can be called with 24 hours notice, same posting requirements. Next slide are the special meeting checklists. It's pretty much the same as regular meetings, except it only requires a 24-hour meeting notice. Yeah, I think everything else is generally the same as a regular meeting. And the next is an emergency meeting. Hopefully we don't have to have any of these. But this is a meeting called to address injury or damage to persons or property or immediate financial loss. Notice is impractical or increased severity of the situation. Must state reason for the emergency at the outset of the meeting. For an emergency meeting, I don't think there's a statutory requirement for the time that you have to post notice. I guess you'd post it as soon as you know you're gonna have the meeting, but you can have the meeting immediately. Next, executive session. So executive sessions could be their own meeting, or they can be within a meeting, but any meeting and part of a meeting of a governing board that's closed to any persons for deliberation on certain matters. The code section for that is 74202. And there's a list of like 6 things that you can have an executive session for. And you have to have an executive session for some of them. Let's go to the next one. Notice must state the reason for the executive session. So example, personnel action, consult with legal counsel. You have to put those reasons on there. You don't say to talk about John Smith. You put on there personnel action, but you don't disclose that type of personnel information in the executive meeting agenda. 48 hours, if it's got 48 hours notice if it's a regular meeting, 24-hour notice if it's a special meeting. It takes a two-thirds roll call to enter an executive session. And so not just a up or down vote, but an actual roll call, and it takes 2/3. And the motion has to state the reason for the executive session, which should be on the agenda already, but the motion also has to say it. During the executive session, you have to stay on topic. You can't be talking about anything else except for the topic identified in the agenda. It's hard not to, because it seems like things are connected. But have somebody, or all of you should be aware, you gotta stay on task on what's in the executive session. If it's not an executive session topic, it needs to be talked about in the open session, not in the executive session. And then the final decision is made in the open session. Now again, I know you guys are familiar with this, you've had executive sessions all the time, but that's something that you always need to keep on top of, is don't stray when you're in an executive session to some other topic. Okay. Who attends an executive session? Well, all the governing board members are entitled to be at the executive session. There was a Supreme Court case I read yesterday that the superintendent isn't necessarily allowed to be in the executive session. They can by invitation, but they're not entitled to. Anyone invited by the governing board can be in executive session. So a member of the public or the accountant or whoever they need to talk to in the executive session can be in the executive session. And it's also helpful to have legal counsel sit in if it's something that might involve interpretation of law. Next, permanent reasons for executive session: personnel selection, evaluation, discipline, or termination, acquire interest in real property. Again, the discussion of acquiring interest in the real property will be in the executive session, but the actual action to acquire interest has to be done in the open meeting after the executive session. Consider records exempt from disclosure, discuss litigation with your attorney, or consider claims or potential claims with the county risk manager or insurer. Those are the 6 reasons you can have an executive session. More on agendas and minutes. Amending a meeting agenda. The agenda is your promise that you won't discuss anything else but what's in the agenda. Only good faith agenda amendments are permitted after an agenda is posted. A good faith reason is essentially a plausible reason why something wasn't included. Maybe we just found out about this new law and we need to talk about it at our meeting, so we're going to amend the agenda to put this new law on the meeting and talk about it. Action items can only be added to an agenda if the item constitutes an emergency. And so if you're amending the agenda after the notice period is over, that 48-hour notice period for a regular meeting or 24-hour notice for a special meeting, you can't take action on that amended agenda item unless you declare it to be an emergency. And you have to do that on the record, why there's an emergency. If the agenda must be amended and it's 48 to 24 hours before the meeting, simply repost the amended agenda. It doesn't require a motion in the meeting to amend it, because it's posted within the amended agenda time period. If the agenda must be amended less than 48 hours or 24 hours, but before the meeting starts, post the agenda as soon as possible to give notice to the public that it's going to be amended in the meeting. And in the meeting, you have to have a motion to amend the agenda and include that good faith reason why it wasn't included in the original agenda. Next. Meeting minutes, super important. Kind of boring, but super important. If it's not in the minutes, it didn't happen. That's our historical record of what happens at our governing board. If it doesn't hit the minutes, it didn't happen. And so it's important that we keep accurate minutes. The minutes reflect what's actually put in the agenda. We shouldn't have minutes that are all over the place, not following agenda items. The minutes should follow what we actually had in the agenda. And there's some specific requirements for meeting minutes, but I'm sure our administrator knows all those requirements. Let's move on to the next slide. Meeting minutes should reflect what was actually decided at the meeting, not what you wish happened. Minutes should be an expanded version of the agenda. If it's not on the agenda, it should be in the minutes. Minutes should not be editorialized. It's just a record of what happened. Minutes create the history of your school district. Minutes shouldn't be a transcript unless required. So you don't have to sit there and type out every word that's said. You can generalize what was talked about and what action was taken. Meeting minutes and executive sessions. So you don't actually take any minutes in executive sessions, but you need to reflect in the minutes that you had an executive session. Reference the specific statutory subsection for the reason that you had the executive session, and give sufficient detail to identify purpose and topic, but not enough detail to compromise the purpose of the executive session. For example, it's probably sufficient to put to consider the purchase of real property. But you're not going to put on there to consider the purchase of 220 Park Street, because it's revealing information that really should be talked about in executive session. Approving of meeting minutes, that's got to be done by the board. Again, anything not in the minutes, it didn't happen. There's no history of it. It has to be in the minutes, or else there's no way to know that it actually happened. Let's go on to the next slide. Public hearings and decision making. So I'm not as familiar with the school district public hearings as I am with the county's public hearings. I know you have to have a public hearing for the approval of the district budget. The public has a right to provide testimony during public hearings, is what it's for. Provided the testimony is within the time allowed, which the chair or the board is allowed to set reasonable limitations or rules related to the public comment period. So within the time period allowed, it has to be on topic. You can't be on other topics that's not related to that hearing. And it has to be within the hearing procedures established by the Board of Trustees.
So this year we had 3 public hearings
Yeah.
because of the deconsolidation.
Oh, okay.
And so the public was able to come and speak and give their opinion about the deconsolidation.
I'm sure I have it on one of these slides, but the actual decisions about the action discussed in the public hearing, you don't actually take that action in the hearing itself. It's got to be done after the conclusion of the hearing and in an open meeting. On the next slide. Special regular meeting rules for Board of Trustees. Okay, I kind of wrote this slide. You guys will know more about this than I do. But the Board of Trustees shall provide opportunity for members of the public residing in the school district to comment on school and education matters at regular meetings. I took that directly from Idaho Code 33-5104. Also says Board of Trustees shall hear public comments, if offered, prior to the taking of action on an action item, and the Board of Trustees may establish reasonable standards for the public comment period. So I went on the website yesterday and I saw that the Mountain View School District had a public input and ground rules document on the website that lays out those ground rules when you need to submit a request to speak at an open meeting. And I went through and actually filled out that form that they had on the website to just test how do you submit to actually speak at a meeting. So my understanding, the way that Mountain View School District complies with this statute is that if you want to speak at an open meeting, if you're a member of the public residing in the school district, that you can fill out that form on the website, submit it 48 hours or 28 hours before well, maybe it wasn't, I can't remember what the requirement was, sometime before the meeting to give the school district time to get it on the agenda. If I just want to speak generally about a topic, right? Same thing if I want to speak about an agenda item that's going to be on the agenda, I need to submit that form. I don't need to submit the form.
So there's 2 ways.
Okay.
If it's a topic that's on the agenda, then you get to speak during that the public comment section at the beginning of the agenda.
Okay.
You just
Okay.
sign your name so that we
Yeah,
know
there's
to
a
call
sign
on you and everyone gets their chance. So if it's something on the agenda, they sign up, they all get to speak. If they don't have something on the agenda but they want to talk about it, like sometimes we don't know that there's
Yep.
an issue, then they would fill out the form and submit it. That way we can put them on the agenda and they can bring this new topic that we don't know about.
And if it's within time before the next meeting to post that on the agenda, then they'll be heard at that next meeting.
Yes.
If it's inside that time period, then I'll have to wait till the next meeting before they can get on the agenda.
And it's possible you'd have a special meeting in that case, like
Sure.
if it was something that was like we need
Yep.
to address it right away. It could be a
Okay.
special meeting.
Does that make sense to everybody? It was something I learned new yesterday, or today actually. May have questions about that process? How to get on the agenda to talk at a
A
regular
number of
meeting?
these patrons sign up and speak,
Okay.
and it's nice.
Okay. Okay, that was a slide that was new to me. Let's go on to the next one. So know your responsibilities. Again, this was written in a format to teach new commissioners about their jobs, but I imagine the school board essentially sits in the same position. On one side, you're a legislative body. On another one of your roles, you're a quasi-judicial body. So when you're sitting in a hearing, you kind of sit as judges. You get the evidence, you determine how you're going to rule on the evidence at the end of your hearing. The rest of your activities are legislative or administrative. For legislative reasons or topics, you can talk with the public. You're voted in to talk with the public. You represent the public. And so if a constituent comes and talks to you about an issue, you can certainly talk to that constituent about it. That's one of your jobs. What you can't do is talk to a constituent about something you're going to sit in a quasi-judicial capacity to determine. So anything that there's going to be a hearing on, or you know there could reasonably be a hearing on, you really shouldn't be talking to anybody about it because you're going to sit as a judge and only accept evidence that's submitted at that hearing. So you can't go around and take a poll of the community on an issue that you're going to sit as a judge on. Does that make sense?
You got an example?
Boy, I do for the county. For a school, I mean, budget's a hard one, right? Because
Yeah.
that's such a big topic.
Gosh, are you noticing that Pole Line Road is getting really rough? I'm a little concerned about buses going out on Pole Line Road. It's so rough, whatever. So you might go to a trustee and say, I'm concerned about that bus going out Pole Line. I'm just pulling that
That's-
By the way, I'm not assaulting any roads in the district. I just pulled one name I knew off the top of my head. So that would be something that you could talk to a trustee about, and that trustee might even drive out there and check it out and go, oh. And then they might reach out to me, and I'd call the bus supervisor and say, hey, can you do a little review of whatever? So that's, you're not sitting in a judicial role there, you're sitting in your legislative role there, your information. But if it's about an employee of the district, if it's about a student of the district, if it's about teacher pay, there's a good share of what the trustees do are in that quasi-judicial. They're acting as a hearing officer to make a decision. Those are things that they cannot have a conversation about, and they can't investigate on their own because they need to wait and get that information in the hearing itself.
But generally, isn't that reserved for the executive session?
Which
The
With
part,
employees.
for example, in employee disciplinary measure.
yes.
So that's reviewed,
so
that's allowed in executive session, but the decision on the outcome is what's shared with the public. Now, as far as discussing that with the public, we're not allowed to stand up and make comment on that. That's where this is coming in, correct?
Isn't there a chain of command on that?
Right. So because the trustee's work is the judicial hearing officer, if it's a disciplinary thing about an employee of the district. And so if you have a concern about an employee of the district, the chain of command is to go to that employee. Then if you can't solve it, go to the employee's principal, and if you can't solve it, then you go to the superintendent. And if it's not solved, then it goes to the board, and then that's when they work as a hearing officer. All of the information is presented, and people are sometimes invited to executive session to state their case. And so in an executive session, then their evidence is given, the other side's evidence is given, and then the trustees sit as a decision officer.
But the decision any decision rendered for disciplinary measure on the employee is not made in the executive session.
Correct.
It's made in the public
Correct.
forum.
And usually it'll say like employee 2024-2025-001. So it wouldn't say the name is terminated at the end of March or whatever, something like that. The only decision that, and this is new, that can be made in executive session, it doesn't have to come before the public hearing, is a decision about student discipline. So we used to have to say, student 2024-2025-001 is expelled from Mountain View School District for a term of 1 year beginning whatever. Because of the confidentiality issues, you no longer have to go to open session for a student decision. All staff decisions have to be made public, yes.
And that chain of command is in that meeting guidelines document on the website, right?
Mr. Jessup,
Yeah.
if we can get back to something you mentioned,
Uh-huh.
I apologize, I didn't write the specific language you used, but I've heard it before in terms of talking about a pending issue.
Right.
So I've always wondered about the timeliness. So I'll pick a topic that everybody knows is coming up, it's common knowledge, but it's not on the agenda, and actually, frankly, we don't know when it's gonna be on the agenda.
Mm-hmm.
But so, let's say sometime this year.
Yeah.
That being, we need to hopefully select a math curriculum.
Okay.
So how does timing play into this when you know you're gonna be,
So the math curriculum would probably fall on the legislative side,
Yeah, it
right?
does.
And so you can talk to any constituents about the
but we
math
know it's
curriculum.
coming up on an agenda.
That's okay, but you can't talk. Okay, so there's two different topics here. One is talking to constituents, one's talking to each other.
Yeah.
So if it's an item that you think is going to be on the agenda, or could possibly be on the agenda,
That's the issue, right?
then you shouldn't be discussing it amongst yourselves. You can discuss it with constituents, that's fine. But if it's something you might take an action on in the future, you shouldn't have conversations with other board members about it. And you have to use your best judgment. But for example though, the math curriculum, I mean obviously that would be something that could come up here, whether it's this year, next year, 10 years down the road.
Yeah.
So that type of conversation should only happen with your constituents or in an open meeting with your other board members. Otherwise, you shouldn't be having conversations with the other board members about it.
So just so I'm clear on what you're saying, we have no plans to put it on the agenda, it just everybody knows it's coming down the pipe at some point, we will,
You shouldn't talk about it with other board members.
period.
Because it's something that
How
reasonably
far out does that go, though?
That's indefinite.
To me, there's, in my side of working on the law, there's a reasonableness concept. And so, let's say, for example, one board member hears about a math curriculum just on the side, however they do, and they just wanna mention it to me, to go, this is really cool. since we know we're pending. So this is like a,
Put it on the
in
agenda.
perpetuity?
Talk about it in the meeting. That's the pressure release valve, right? You certainly can talk about it all you want with your other board members, but in a meeting with the
Oh.
public present. And the public can talk to you about it, but what you can't do is confer with other board members and say, I think this is a good idea, or we should look at this curriculum. That should be done in an open meeting.
Interesting.
I thought I read in here that it's okay if less than a quorum can talk to each other, but once a quorum is achieved,
Yeah.
that conversation cannot take place because it would be misconstrued as conducting business.
I would say no. I'd say that's,
Okay, but
it
is
says
that,
it
is that,
both, it
is
says it
that
both
no
ways in there.
on your opinion, or is that no on, the law?
There's guidance both ways in that document. And there's guidance that says it's an open meeting if there's a quorum present, right? You have to have an agenda for it.
Right.
If there's board members talking to each other about a topic that should be in an open meeting, regardless of their number, whether it's 2 or I guess 3 is a quorum, but 2 shouldn't be talking about it, because it's something that the public should know their thoughts and feelings on, right? It shouldn't be something they should privately confer and try to change the opinion of other members. And there's a term about this, I can't remember, it's like it's a serial meeting or a walking meeting, where it's, say I'm a board member and there's 4 other board members, and I go talk to every one of them individually, right? It's not a quorum, but I went and tried to influence every one of them on this topic. That's absolutely against the open meeting law. You can't do that. You can't try to talk to your other board members outside of a public meeting.
Right, because the intent there is
Right.
undermining the whole purpose of the open meetings law. But going back to, akin to the commissioners, where they're allowed to talk to each other one-on-one, but
They actually can't, because there are 2 of them as quorum, right?
right,
There's only
but
3 of
there's
them.
an exception in here.
The exception in there is to talk about non-county business, and same thing with school board business. They can meet and have coffee, they can talk about the buckskins, but they can't sit there and talk about the math curriculum. They can't have conversations about things that should be open meeting items discussed in an open meeting.
Right.
But they certainly can socialize and have coffee and talk about their political aspirations, but they can't talk about stuff that needs to be talked about in an open meeting. in
No
front of
matter
the
how
public.
far off in the future that potential
I'd say no.
subject may be.
I'd say no. I'd say have it here. I'd say if you're interested in that topic and you want to share your thoughts with the other school board members, just have an agendized, and you can just talk all you want in your open meeting about it.
Okay, what if there's a vote for the new chair, and you ask the old chair, just if they would be interested in continuing to be chair? It's kind of respectful, like you don't wanna,
Okay, that's a great topic for an open meeting. I know what you're saying, that it's public, but
should not
it
do
should
it.
be done in the light, right? It should be an open meeting thing. We should know that you don't want to be chair. The public should know B's not interested in being chair, rather than Tyler having coffee with you and saying you should be chair. Well, that seems like something the public should have heard. Okay?
It's more of like a respect, like I don't wanna throw you to the wolves, but will you please
I
be
know.
chair? Yeah.
But we're pretty exposed in these positions, right?
Mm-hmm.
The stuff related to the board should be happening in the public unless it's an executive meeting topic.
Okay.
Truth will set us free.
What if there's, no indication that it will come up in a public meeting?
No indication, like, it's not as,
It could, maybe it
I
will,
would say
maybe it
anything,
won't.
I would say
who knows?
anything related to the
Roll of the
school is
Yeah.
gonna be something that could come up
Wow.
in a meeting, right?
But if, again, you're talking to maybe someone that is considering a teaching position. They might have some interest, they might not have an interest, I don't know.
So
But
you're
just
talking to a
about
future
general.
teacher
Uh,
who reaches out and says, how's the school district?
Who knows?
I would like to teach there.
Yeah, who knows, again, they might just be trying to find out more about your district. More about, the community, more about whatever, and you're just talking.
If they're talking to you as a constituent, I think that's fine. If they're talking to you about a potential job opportunity.
How do you draw the line between that being a constituent versus being a trustee?
Two ways. Use your best,
Best guess.
best guess,
Okay.
or talk to your attorney. And ask, if you have a particular question, you can ask your attorney, can I talk to this person about potentially being employed with the school district? But I would say, it's gonna feel awkward, but no, I just wouldn't talk to them about it. If they're talking to you about a potential future with the school, No, because you're gonna be sitting in that quasi-judicial capacity to potentially be determining whether or not they should be hired.
But you could say, I can't really talk to you about that, but the principal of that school
Absolutely.
is.
Yep, they're not confined to that. The principal can talk to them, superintendent can talk to them.
Okay.
The board members just can't talk to them about that thing that could come before the board. Good question. Okay, anything else on this knowing your responsibilities, the difference between legislative and quasi-judicial?
So Matt, question. So I talked to Larry and I said, Larry, I'd like to talk to you about, PragerU and Hillsdale 1776. He can't talk to me because he's gonna possibly make a judgment on that in the future?
If it's legislative, which I think this is, is there a hearing on curriculums, or is it, so it's legislative, you can talk to him about it. What you can't talk to him about is that you don't like teacher Mary Smith, and you want her to get fired. You can't, or whatever other topics that the school district has, they have a formal hearing, that's the only place they can gather evidence in. But certainly, that curriculum, constituents can talk to any of the board members about curriculum, about the basketball teams, anything that's not gonna do that
We just
quasi-judicial.
can't talk to each other.
Can't talk to each other about, you can, absolutely you can talk to each other, but right here in this room, after an agendized schedule.
Could
what
I offer
happens
some
if
caution
if
about the
parent-
basketball team? Because if the
Oh.
conversation with the trustee is, well, we have way more talent than we have record. Man, we should be winning and we're losing. Oh, that puts you into that quasi-judicial, because that coach's contract may come before the board
Sure.
based on their performance. So
Sorry, that
yes,
was-
you
I
can
just
talk
casually
about
threw that.
you can talk about the basketball team going, woohoo, man, that number 25 scores a lot of points or whatever.
Well,
That's
we can't
great.
talk about
but
something
if
that may lead to
if
an
it may
employment
lead
decision.
to a decision,
Yeah.
then you can't.
Sure, sure.
So if a parent has an issue with something that took place in a school activity that could come to a point of discipline for somebody, what happens
Then
then?
go through that chain of command and bring that up to the person maybe that was in charge of the activity, whatever that chain of command is, and I don't have that in front of me, but go through that chain of command, and that's how the board will be, at some point, maybe it's not resolved, that's how the board will be notified, is through that chain of command. Okay, let's go on to the next slide. Public hearings, they occur at a public meeting. The final decisions are not made in the public hearing. The public hearing the decision happens after the public meeting is closed and no more evidence is considered. And then the final decisions are made in the public meeting or a future public meeting. Next slide. You get to set the ground rules, and the school board already has. We already talked about those. You can adopt rules of order and procedure to govern regular meetings. You can place limits on the length of comments, reasonable limits. You can't say it can only be 2 seconds. There's some reasonable limits on the length of comments. And you can place limits on the topics. But obviously we already have a procedure for that. We talked about that tonight. It's on the website.
Yeah.
Yeah.
So there's nothing in the rules that prohibits the board from talking back to the public. There's nothing in there that says thou shalt not have a conversation with the public. That only comes about if they make up the rules or establish the rules to say such.
It's generally up to the chair to decide if they're going to get more information or ask questions of the public. And I don't know what rules of order you have adopted, but it may say in the rules of order as well how questions should be directed to the chair and then to whoever. And if not, maybe that's something you can explore. But yeah, I don't think it doesn't explicitly say in an open meeting that the board of trustees can't talk to the public, but they can set those rules of how they're going to operate the meeting.
So it's my understanding that if I get up as a public entity or a public person to address the board under the rules with the 3 minutes,
And your topics on the agenda.
and the topics on the agenda, the rules here are that the board will not respond to any questions or comments that the person makes in that 3 minutes because, and in the past, I've heard it violates the open meetings law. And in reviewing the open meeting law, I find that's not true. It's more to the point that that's a rule that the board has made to the public.
I believe that's a correct interpretation of that.
That is
So-
correct.
Because as long as it's on the agenda, can discuss it. And that discussion can occur with the public as well. But again, the board and the chair sets the rules for the meeting, and they can decide how they're gonna operate under those rules.
I would agree. I would just say that best practice is typically not to respond, because one trustee shouldn't speak for the board. They should have an opportunity to get information, formulate a response, and then they should respond to it at the next meeting. So if you come at a meeting and you have a question, why are there white lights out there instead of the low-level yellow ones? They're more friendly, whatever. The trustees really shouldn't respond at that moment, because it might be about power, it might be about what's paid for by the state, whatever. That information should be gathered for them. They should be able to discuss it in a meeting, like at the next meeting, and then respond to your question.
My point, though, is that in response to the question of why don't you respond to my question, we can't, because the open meetings law forbids us from engaging in that conversation during the meeting. That's my question, is there anything in there that specifically prohibits the board members from speaking during that? And if it's not in there, then where it's at is in the rules that the board establishes. So at some future date, the board could, in theory, change the rule to engage in conversation, two-way conversation with the public audience.
And I think the chair could do that ad hoc as well under the Idaho Code.
It happens occasionally. We have it happen occasionally. I think generally it's under their governance, just to not get a meeting that gets too long or out of hand, or they get off topic or off agenda. So it does happen occasionally, and I agree. It's not open meeting that's keeping that from happening. What's happening is you want to be careful that you don't have a trustee that overspeaks in response, and then finds out, oh, that was inaccurate information because of whatever.
We've had that. This is an interesting topic, because I don't know how many of you have been here for a lot of years, but if anybody in this room knows Ray Stowers and Harold Gott, those names ring a bell. They used to be on this board. Now I know Lori knows this because she's been here for years. When they were on the board, we would have conversations. They would stay an hour after the meeting to have conversations. And Ray told me this week. He said, you can go ahead and tell them. We used to stay out after an hour just so we could resolve issues with our community, because that's what we were here for. We were here to talk to them, find out what the problems were, and try to resolve them. And I would say you probably know that. You were here.
So I'd like to talk to that real quick, actually. So that's super interesting. And the open meeting law is super helpful to the public to know what's going on, right? But only if we use it. And it's very restrictive. I mean, it's bureaucratic, and it's administrative, and it slows things way down, right? So Mr. Stowers and Mr. Gott, they may have done that, but they really shouldn't have, because now they're sitting there talking about topics that are not on the agenda.
We didn't say the topic wasn't on the agenda.
Okay,
I didn't say
it
that.
was great, but it should be in an open meeting still, and taking minutes on it, and getting that memorialized.
Well, they took the meeting over an hour, overtime.
It was still an open meeting, they're still doing it
Talk with the public.
on the agenda.
To talk
items.
with the people, get their input. What do you think about this? What do you think about that?
So you were just talking kind of on the same topic. Essentially, they were interacting. Okay.
Well, I mean, this is their community.
Yeah.
And Matt, the board used to do that. I remember in Elk City, half an hour before the meeting, we could have dialogue with the board.
Well, you should.
But that stopped.
It's got to be on the agenda.
Well, this was before the meeting started, before you threw the gavel down. He's talking about 30 minutes.
One-on-one you can, but you can't have multiple trustees in a room having a conversation. Then you're talking about an item that should be in an open meeting, right? So if you want to pull a trustee aside and talk to them before a meeting, you certainly do that. But what you can't do is have multiple trustees in a room talking about a topic when you're not in an open meeting taking notes on the agenda. Bruce?
Well, I'm just here to observe, but I've had numerous people come to me and tell me the way that meetings are run, and you're gonna have to correct me if I'm wrong on this, but what I understand, even if it's an agenda item, you have an opportunity to speak for 3 minutes. Is that correct?
Yes. Open.
And after the 3 minutes, you said what you have to say, and the the board does not have to respond to you, or in most cases, does not respond to you. Is that correct?
Yeah,
So
right.
the
That's been the
complaint
operating
is-
procedure, yeah.
The complaint is that we have no interaction between the person that got up and talked for 3 minutes and the board. So it's a one-sided conversation.
Yep.
And that seems to be the complaint that I hear from the public. And I'm not trying to say I know what's going on, but I ran meetings for 10 years. I ran them before the open meeting law and once it was instigated. I can tell you that you have some latitude. You do have some latitude. You can set your rules if you want to set your rules at 3 minutes and nobody gets to talk again. And you can set your rules, am I correct on this?
Yeah,
And
go
you
for
can
it.
set your rules that you don't have to respond. And you can set the rules because, well, we want to have the opportunity of the board to investigate this. But if it's an agenda item, then I see no sense in that at all. If it's an agenda item, you should be able to have some dialogue. And I'm just pointing out to you from what the public is, what I hear from the public is that we have a communication problem between the public and the board. They feel isolated. They feel like they have an opportunity to come and talk, but we can't talk back and forth. And I'm not saying we have to talk back and forth all night long, but it seems to me like if it's a topic that needs to be addressed, even a half an hour would not be out of line to talk about back and forth. So this idea that you have to come back the next meeting, it just doesn't make sense. And then at the next meeting, is there any, what's the rule at the next meeting? I don't know what it is. Can you talk back and forth again?
It'd generally be the same, right?
So it should be the same. There's wording in the code that says it should be, the rules should be somewhat reasonable. I don't
Yeah,
know.
I think reasonable's in there.
Yeah, and it just seems to me like maybe these rules need to be looked at. Maybe they're not reasonable.
I felt like that as well,
Yeah.
for a long time. And I kind of looked at it as you should be talking to your zone trustee about your issues and meeting with them. I'm always available for any of my constituents. I'll meet with them wherever they want, almost whenever they want, if I'm available. 'Cause I was chosen to represent those people. And so if you feel like, or if anybody feels like they might be left behind, maybe it's best to find out who your zone trustee is and to make a meeting with them and help them understand what you're feeling and have a dialogue.
My thought on this, and it gets back to the whole thing though, is that what we're hearing from the other side is that, oh, we're not allowed to speak then to them about, to get more information about what they may bring up. Maybe it's something that we weren't aware of. And we'd like to at least get more information about it before we carry it forward. That, again, we need to understand.
And again, it's set in the rules for the board and how the meeting is operating. And I understand both sides of this. I understand the public wanting to participate almost like a board member and being able to have that ability to do the input during the meetings. Unfortunately, that can really jam up the administrative function of the school board to me to make decisions, right? B had a great example of how you can get your point across. Unfortunately, it's not going to be in front of the group. It's not going to be in front of the board, but to your individual board member or any of the board members, whether they're in your district or not, you can talk to them outside of the public meeting and tell them your point of view on an issue. They can't talk to each other about it, but you can certainly tell them how you feel about something outside the meeting.
And then,
That the example I gave you of the past meetings and the past people that were on the board didn't jam up anything. It actually solved problems. It made it better. It made it easier. It was so much better.
Sure, and I can't speak to that. I wasn't there, and I don't. Again, that's up to the board to decide on how the meeting is going to be run in a
And-
reasonable
Matt,
manner
I'm
under the
not gonna
statute.
disagree with what B's saying, and that's fine if you wanna do that. But every person, every patron should have the opportunity, if they so choose, to come to face the board. and to have a two-way dialogue for a reasonable amount of time.
And I'm sure they're hearing you tonight on that.
The
and- but
easiest,
again,
the
it's a-
easiest best way to, the easiest best way to do that is to fill out the form and ask to be on the agenda. Because when you're on the agenda, you are the speaker and the listener. I mean, that's the dialogue right there. When you get on.
I'm just telling you, what I'm hearing from the public is, even if you're on the agenda, there's no two-way dialogue.
Oh, if you're on the agenda, it should be. I would encourage that. That's the purpose of you getting on the agenda.
Is that-
The
is that
only
the way
thing,
it is?
the only
There's a
thing is
two-way
I
dialogue?
would say like,
Well,
unless
if
you,
you're,
yes,
if you're on the agenda itself.
yes.
You can sit here and discuss it back and forth.
But that's not signing up there. I mean, beforehand, you would get on the agenda and we
So
put you
what
on
if
the agenda.
20 people wanted to be on the agenda, talk about
Well,
how?
we wouldn't be able to.
They have to set limits for that. I don't remember off the top of my head
You know,
what it is.
This
for
has
limits,
obviously
but-
been a frustration from day one.
And I
That's
do
why
have
we went
a-
to
I
those
do have a-
workshops, remember? We were just like, we need to open up this dialogue, okay?
If I
Because
do have a
everybody was
qualified-
just frustrated.
If it becomes about a person, I'm sorry to have
No, that's
interrupted you.
fine.
If it becomes about a person or a student, like confidentiality, that'd have to be shut down.
So I'm wrong.
But if it's
wrong.
about a bumpy
But
road,
a solution to this is, and this is how we dealt with it, is when you have an item come on your agenda where you think that there's gonna need to be public participation, because you only conduct 3 public hearings that sound like a year, you can automatically put that on as a public hearing, so that the public will have the ability to not have that disconnect where they can be heard. So it really depends, and the chair recognizing that fact, if an agenda item's coming up and the public's gonna need to have discourse on this, put it on as a public hearing.
Right.
Well, not necessarily. The public hearing is a specific legal mechanism to take evidence for a judicial decision, quasi-judicial decision for the board. So I would call it a public hearing. You're talking about like open forum, I think is what you're saying. On the agenda, having the ability
It
for
depends
anybody.
on the item that's on the agenda, that's what I'm saying.
But the rules right now, the way they're set up, you can speak on an agenda item, but you've got to sign up in the back, essentially,
well,
right?
there's 2 ways. You could, if you just have something you want to say, then you just sign up there and you speak. You just say it. But if you have questions, if you need dialogue, then I would encourage you to get on the agenda so that you can have
So I guess
that
I'm wrong.
dialogue.
I asked you specifically, and I'm just trying to get the gist of this. I said, if you're on the agenda, my understanding is, you get 3 minutes to talk.
No,
No.
That's
no.
wrong.
That's signing up before if you just walk through the door, you could sign up to make a statement.
Okay, so if you're on the agenda,
But if you approached us ahead of time, like a week ahead of time when we made the
I'm
agenda.
on the agenda.
So like last week, had you
Okay.
been like, I want to be on this agenda, and requested that.
Talk
And we
about
put you on
curriculum or something,
to
yeah.
talk about subject A or
And
whatever.
then we go.
Then you put that on the agenda, then you would stand up and we could talk about it.
We go back and forth
Go back and forth.
until you decide it's over, which is fine.
Yeah, something like that.
But your public comment period at the beginning of the meeting, it's not a back and forth.
It's
that's in-
not,
that's in your
and
rules,
that's what's
is-
the frustration in the
Sure.
community has been.
Sure.
I understand that.
We've
I
been
mean,
trying to
I don't
work
have-
around
I don't have
that.
an issue
Well-
with that particular policy.
Matt, just to, 2 quick things. One, for whatever it's worth, not an excuse, just what it is. Since I got here, and this does not include anybody that was there at the time, except for maybe the recollection of 2 other board members here, we were told we could not. We were told the same thing, which gets back to my complaining that we need more training, but that's another issue. That's what we're trying to catch up to. The second thing, I just want to make sure I understood what you told us earlier, with respect to the concept of an open forum. The ability to just to take questions, first come, first serve. The chairman, we could make that if we chose, hypothetically. We could make that part of the regular meeting, hypothetically, for the first 30 minutes, so long as the only topics that were talked about or brought up were the ones that are on the agenda. We could do that if we wanted to if we wanted to change the rules.
If you wanted to, any agenda item, anybody can stand up and have a dialogue
Yeah.
on that agenda item.
We could do that.
You could do that, yes.
Yeah, I'm just saying, because we have what I'm hearing you say is we have the authority to change that 3-minute rule.
Yes.
Okay?
Well, we can still do the 3-minute rule and then just have a 15-minute conversation.
Well, I'm just
after
saying we have the
discuss it.
ability to.
I mean, we can figure that out, but I'm
Yeah.
just saying, we can do something
I
of
think we
that
should look
nature.
at that, absolutely.
So
That is
1500, our policy 1500P is something, that's what we'll need to edit. Because it specifically is the board meeting procedure.
That's why that's one of that list I wanted to have for our board procedures.
And I think where our hangup was the last paragraph says, meeting conduct in order of business is Robert's Rules of Order. And so the use of proxy anyway, so I think that's something that we'll need to really look at.
We've been doing this from day one.
Right.
Because we started with workshops, and then we were.
tried.
Then we shut down the meeting, and
Yeah.
then we talked, and then we opened up the meeting again. I mean, we've been trying to get
Right.
past this issue.
Yeah.
I mean,
Yeah, well-
this whole year we've been trying to get past this issue.
Right.
But it's good, I think we're
Legally.
making progress, and everybody's
Yeah.
getting the same information at the same
Yeah.
time. That's why I'm very glad you're here.
But then it was like, oh gosh, we might be in violation, and we might get fined, and might go to
Right.
jail, and oh gosh.
We can be personally
What do we
prosecuted.
do now? You know, so we're
It's
trying to
gonna
work
be
through
his
this.
office.
If you guys have been around, you know we've been trying to
All
work
right.
through this.
I,
The whole year.
I for one would like you to make sure you get finished with your presentation.
Okay.
Yeah, sorry.
Yeah.
No, no worries.
We're up
Okay.
against the clock at this
Yeah.
point.
Right now.
So we talked about this at length here. Bruce, did you get your question answered?
I think so.
Okay. Okay.
Can I just say one thing?
Yeah.
I think it's been a little bit unclear that you have to sign up on the website, so I wonder if that could be more prominent somewhere, that is how you actually get on the agenda, by the board.
I found it on the website. Is it anywhere else that we have that notice posted? Maybe on the, do we have room on the bulletin?
It may be somewhere else, but I could look.
Because I think people have been signing up on the day of, on the little piece of paper and not realizing that there is an opportunity to have back and forth, but you get on the agenda if you sign up on the website a week ahead of time or whatever. Can that be clearer somewhere?
Where would you suggest, because that's a good idea, but I'm trying to figure out like where else could we put it?
Can it be announced at the beginning of each meeting?
Yeah, for the next meeting.
Yeah.
I think if we had some of the policy printed and just put it beside, we just have to be really careful that people understood, you sign on this one, you talk tonight, but there's no dialogue, you sign on this one, you get on the agenda for the next
Exactly,
meeting.
yeah.
So we could have some printed and available.
So for clarification, if you want to get on the agenda, and you do, you don't have to speak about the topics that are on the agenda. Is that correct?
You have to speak about the topic that you put on the agenda.
That's right.
Yeah.
But not what's already on there.
When it's your time to speak on your agenda item, you're just gonna talk about what's on your agenda.
That's like what
Yeah.
you did last summer when you came up and talked to us about the levy. That was the mechanism that you used when you did that.
Question?
That's if we put you on the agenda too. It's not a guarantee, but we'll try. I'm just saying that's if we put. But if we have like 50 requests,
Redundancy.
you can't get through an entire
Well, and
meeting.
maybe if we get 50 requests on the same thing, that's when we
Then
can
we
look at it
know
open,
we need to talk about that.
whatever. I never
I
remember
actually
the
think
terminology, but
I think there says something in the policy that if there are multiple requests about the same topic, they'll be asked to reduce them to writing. I think, I'm paraphrasing, and I lived a long time in a different district, so I might be using
Yeah.
their policy, but I think there's something in the policy.
and that would be just kind of a notice that maybe we need to have
We'll get
another
that
meeting
out and
about
make
it.
sure there are copies here available.
Okay.
Question? Regarding this, written request to be put on the agenda, there's, the way it's been proposed, it's been discussed, at least the way that I've been hearing it so far this evening, is, for example, if John wants to go and say, I'd like to talk about XYZ, he'd go and submit this. Does that enable others than John from the patron base to talk about it, or is it just John?
If the chair allows. I think under the current mode, no, it's just the presenter, right?
But
It
we're
could
trying
during the
trying to
session.
bring more people into it. We're trying.
Okay.
But the point is, it's legal to do that.
Sure. Yeah, as
And
long as it's on
maybe-
the agenda. Yeah.
And maybe if there's 5 of you that want to talk, you could all get together and
Do it as
ask
a
for that
group.
agenda item, and you all
Do it as a group.
do it as a group.
Yeah, that'd be great.
So one person signs up and then a group.
Well,
Well,
it
you
would
got the
probably be
individual.
like
List the people on that. List the people on
John,
the group.
John, Bruce, Roger.
You can never have too many Jones.
Yeah, but it's how you spell it.
The day in.
Okay, let's go on to
Oh
the
yeah,
next slide
keep
here.
going. Thank you.
Ground rules, obviously you guys are already practicing this. Establish clear ground rules, be respectful, don't speak over other people. Speak up when the conversation veers off the agenda. Just like we have to keep executive sessions on topic, we have to keep agenda items on topic. We can't be talking about things that aren't on the agenda. That's up to the chair to make sure that you stay on topic. Acknowledge strong feelings and redirect to the agenda item. If one person dominates the discussion, call on others to participate. Again, these are just guidance from the IAC. You can operate your meeting however you want. Let's go to the next slide.
Hey Matt, that one that said acknowledge strong feelings, that's in violation of Supreme Court law. It says you can vehemently express your opinion. I've got case law that says that.
No, that is a way for the chair to maybe help tamp down the meeting a little bit. That wasn't restricting anybody from their speech, their First Amendment rights to speak. You obviously have that right. It was encouraging the chair to acknowledge that obviously you have strong feelings on this topic. It was more of a crowd control than a restriction on the public participation. You have your First Amendment right to make your comments as long as they're within the rules of order and respectful.
Yeah. Well, they don't even have to be respectful. They just, not that I wouldn't be, but they don't have to be.
I wouldn't give guidance on that tonight.
But as a chair, I can gavel it and stop, right?
No.
Control the meeting.
Because you control the meeting.
We're in a real gray area between First Amendment
so
rights
tough.
and, yeah,
So tough.
I'd have you refer to your own attorney on that one.
Let's try to be civil.
Try to
That's
be
what I-
respectful.
just try to-
The commissioner or the chairman should try to run the meeting respectfully and civilly. Let's go on to the next slide there. We can move on to the next slide. It's kind of a little off topic. Let's go on to the next one. Let's go on to the next one. Go on to the next one.
Oh,
Can you
do you have an
back up
We
one?
go back
Back
one.
up one. Avoid
No.
motions like so.
Darn.
moved.
State the motion.
It says avoid, it doesn't say are prohibited. Which it doesn't.
At the very least, it's got to be in the record in the minutes as to what the motion was. It's good to recite it so that the person recording the minutes has exactly what you want.
and so you know what you're moving on.
And you know what
Those
you're
were
moving.
very quick eyes when I saw
So
it.
it's good practice. Recite exactly what you want to have in the minutes.
Great.
Decision making. A valid decision is made at a posted board meeting with a quorum present on the agenda and listed as an action item. So they can't make a decision on something unless it's listed as an action item on the agenda or there's an emergency. It's got to be made by motion. It's got to be voted off by the board and recorded in the official meeting minutes. Next slide. Decision making is not polling the board. And so how does everybody feel about this? Do a hand count on this. No. The decision is made by motion. Some decisions are made by oral motions. Some are by head count. You can't do it by gathering signatures. You can't make a decision based on an improperly posted agenda. Can't make decisions without a quorum present. Made without being listed on the agenda as an action item. Redundant. And then you can't deliberate outside of a public meeting and then come in and make a decision unless it's one of those executive session exceptions. Otherwise, that discussion, that sausage making, has got to be done in public. Next. Types of violations of open meeting laws: inadequate notice on the agenda, decisions made on topics that are not on the agenda, decisions made on topics improperly added to the agenda. So maybe we say it's an emergency, but we don't say why it's an emergency, and we make a decision on that. That could be an improper or an open meeting law violation. Decisions arising from deliberations occurring outside of a public meeting and failing to disclose a conflict of interest. We're not talking about conflicts of interest tonight, but that could also be an open meeting law violation, not disclosing that potential conflict of interest to the public. If you violate the open meeting law, the consequences for a violation could be it renders the board's action null and void. And any board members participating in an illegal meeting may be subject to civil penalties of $250. Civil penalties, not criminal, but civil penalties. The criminal piece of it is separate. But under the open meeting law, is a civil penalty, or $1,500 for knowingly participating in an illegal meeting. That was a little harder to prove. And then $2,500 for multiple knowing violations within 12 months. Knowing violations within 12 months.
Plead ignorance, impossible.
Talk to your attorney about that. Next slide. Curing an open meeting law violation. Nice thing is the law gives us an easy mechanism to cure a violation. And so if a violation is identified, the board votes and says, yes, we had an open meeting law violation. Vote to nullify it and then take it up again on a future agenda. And that would cure it. Essentially it's null and void whatever action you took, and then you have to decide if you're going to consider that action again or not. It's got the curing process must happen within 14 days of a violation, and the cure protects you from the civil penalties we saw on the previous slide. Next slide. Prohibition of serial meetings, we talked about serial meetings, that's having, like we talked about before, going to each commissioner or each board member and talking to them about a topic that's gonna come up. So maybe you're not forming a quorum, but you're going around and you're polling the different board members. You should not do that. Board members should not talk to each other about stuff that could potentially come in front of the board. Direct communication would be things like email, text, talking to someone face to face. Indirect communication would be reaching out to a constituent and say, I think you need to go talk to the other board members about this thing, because I really feel strongly about this and I'm gonna vote to do this thing, and you need to go talk to some other board members about it. That's indirect communication, that's also inappropriate. Okay? Communication with communication with constituents, gathering information is generally okay. Avoid using constituent interactions to pull other board members or form a consensus outside of a meeting, and be transparent. So if a constituent talked to you and it was a fairly significant conversation, you should probably disclose that conversation when you're talking about that item in an open meeting. I talked to Bob Smith about this. We talked for half an hour at the coffee shop. Bob Smith had some real strong opinions about it. He told me that he really wants that road to be closed. You should probably disclose that if you invest a significant time talking to that constituent about it. It's not mandatory. This is use your best judgment type of thing. But if you had a significant interaction with a constituent that really maybe influenced you, you need to probably disclose it in the open meeting that you had that interaction. Next. Best practices, err on the side of caution. Document communications. So even communications you have with constituents. You might want to keep a journal. I talked to so-and-so about this topic today. I talked to so-and-so, and again, that could help you if you do talk about that topic in an open meeting, that you can reference your journal and see if there's anything significant in there. You should probably tell the board. And then seek legal advice from your attorney if you have questions. There's going to be situations that come up that this doesn't answer directly, and so you're going to need to talk to an attorney about it, whether or not there's been an open meeting violation. If you need to do something to prevent future open meeting violations, talk to your attorney about it. Next. Can a patron communicate with a single board member outside of an open meeting? Yes, and we talked about this, but no serial meetings. Emails and letters from patrons to trustees about trustee business are public records. And so I, as a constituent, I can email my trustees, or I can text my trustee information, and they can potentially respond back to me. But what they can't do is forward my email on to the rest of the board and say, I think Matt had a great idea here. We really need to consider this for the next meeting. That's problematic, because now they're communicating how they feel about the issue. They're communicating to the board members. Probably they should forward that on to maybe the chair or superintendent to get it onto the next agenda item. But probably not discussing their feelings on that constituent's communication. Now, if you just forward that constituent's communication to the board, or I don't know, you guys might have channels on how you do that.
Kind of filtering it through the clerk, right?
Yeah.
That's kind of been our.
Maybe that's the best way to do it. Get those communications to the clerk, and maybe the clerk will disseminate them to the entire board. But what the different board members can't do is communicate to the other board members how they feel about that constituent's communication of that topic that the constituent brought up. Questions about this question? Okay, next one. Can trustees email, call, or text each other on a matter that would foreseeably come before the board? No, we can't. Even the discussions between two board members is too much, because now they're coming to a conclusion on a topic that should be discussed as a whole board. Next. Can two or more trustees meet for dinner with patrons to discuss a matter which could foreseeably come before the board for action? Well, you can meet with people for dinner. Two trustees can meet with people for dinner. It'd be kind of awkward if the whole board goes and meets with patrons for dinner. But as long as you don't talk about anything that could foreseeably come before the board, it's not an open meeting law violation. It's going to be hard when you have the whole board there. It's better maybe to have one person at the dinner with the constituents, but you could have two. You just can't talk about any school board related topics that it could potentially come before it. Questions on that slide? Next. Can a board of trustees hold a town hall meeting? Yes. However, open meeting law still applies. If a quorum of the board is present at the town hall and they discuss or deliberate, I'm gonna change this a little bit. It says quorum here. I'm gonna say if more than one board member is present at the town hall, well, they shouldn't do it. You should have a quorum at the town hall, and you should have an agenda, and you should have minutes. It should be an open, public meeting. Even though you're having a town hall quorum, or a town hall meeting, we kinda talked about that, that's a possibility. We've done that on topics before, but it's gotta be on an agenda that's properly noticed, and you gotta keep minutes. And it has to be open to the public. Next slide. Ah, that's it. Any questions?
Hey, yeah, can we get a copy of your slides?
Yeah.
I have.
Yes. I think I've changed them sufficiently that I won't be in trouble for plagiarizing. Let me think about that. I'm gonna have to
Okay.
take a couple of slides out.
All right.
Okay, changing the agenda right at the beginning of the meeting. So I was at the Orfino board meeting in 2020 when they changed it and added masking the kids. And they added that to the beginning of the agenda, and they said that there was a doctor that's on the school board, and she said, we're doing this for the health and safety of our staff and our students. Well, then the next day, after they had voted to yes, mask the kids in Orfino, it was overruled the next day. Somebody had said they didn't add the agenda item correctly.
Okay.
So that's always
So
changed.
it was a regular meeting,
It was a regular meeting.
and the agenda had already been published,
Uh-huh, and they
And-
added it at the beginning,
added at the beginning.
said it was an
and
emergency.
Did they put it on the agenda, or in the motion, that it was an emergency, and the reason for the emergency?
I
They
don't
should
know.
had a motion to amend the agenda,
Yep,
and then approval of amending the agenda.
yep, but
And the
then,
reason for amending the agenda.
they would have needed to say in the motion,
That it's an emergency,
okay.
because there's a risk of loss of life.
I don't remember that
We did
detail,
this.
but it's always made me wonder, like, why was that, I mean,
So yeah,
So
so
they may- they
I
may have
move
just-
that we amend the agenda to discuss masks due to the imminent danger of life
okay.
to students. And if they don't say why and declare it the emergency,
Okay.
then it doesn't count.
Cause that's always troubled me the last 4 years, like, how to add and what to add when.
Yeah.
When the agenda is submitted at the last minute like that, what's the number of board members that must vote to pass that?
Majority,
A majority, simple or
Simple.
super?
simple.
Now, if they're subscribing to Robert's Rules of Order, I believe in Robert's Rules of Order, at least that's how we conduct our meetings. If you wanna change the agenda in midstream oh, I'm sorry, I correct myself. If we're changing the agenda in midstream, it requires super majority. But yeah, simple majority can change the agenda at the beginning of the meeting, so I think that's the answer to my
Okay,
question.
okay. Anything else? Interesting topic. Thank you guys for putting up with
Thank
me
you.
tonight.
Thank you
Thank
so much.
Always talk to your own attorney about it.
I love that. Careful of the code.
15 minutes.
15-minute break.
Yeah.
Thank you so much.
You feel this shit?